The human rights lawyer, Falana, is demanding the immediate release of former chairman of the Economic and Financial Crimes Commission, Bawa. Falana, in a statement issued, says the remand order for Bawa had expired and that there's no legal grounds to continue to detain him. The statement reads in part, in view of the fact that Mr. Rashid Bawa is not being charged with any criminal offense whatsoever, the State Security Service ought to have released him from custody. I am not unaware of the claim that Mr. Bawa is being detained on the basis of a remand order issued by a magistrate court in the Federal Capital Territory. It ought to be pointed out that the remand order has become spent, invalid, and illegal, as no magistrate has the power under Section 493 of the Administration of Criminal Justice Act 2015 or Section 35 of the Constitution of Nigeria to authorize the detention of a criminal suspect for 67 days without trial. He added that under the Administration of Criminal Justice Act, the cumulative lifespan of a remand order is 56 days, therefore having exceeded the detention period permitted by the Administration of Criminal Justice Act and the Constitution of Nigeria, the State Security Service should be directed to release Mr. Abdulrashid Bawa from illegal custody without any further delay. Just to mention that Mr. Bawa has been in the custody of the Department of State Services since June 14, 2023 for alleged financial impropriety under his watch. Now, to speak further on this, I'm joined by Mr. Eze Onyekbere. He is the lead director, Center for Social Justice, and he is a lawyer as well. He joins us virtually. Mr. Onyekbere, thank you very much for joining us.
My pleasure.
I don't know if you've seen the statement from Mr. Falana, but I just read it out, and he says that the action of the EFCC, or the federal government as it stands now, is illegal as the remand order day has expired.
Well, let me start by saying that under the Administration of Criminal Justice Act, as he rightly pointed out, the detention order can be for a maximum of 56 days, 14 days times 4, 14 days times 4. So anything outside that period is illegal and cannot be justified under existing laws. Let me even go further to make this point. I think many of my senior colleagues particularly are not adopting a proper jurisprudential disposition to those sections of Administration of Criminal Justice Act. I recall as a young lawyer so many years ago when we were in the Civil Liberties Organization, we fought so hard to declare a holding charge illegal. And what the Administration of Criminal Justice Act has done is to more or less justify the holding charge, and you have a situation where you are holding somebody for 56 days and you are not able to bring a charge. If you look at Section 35 of the Constitution, it is clear. It says you should be able to charge somebody, bring him before a proper court within 48 hours. And then it gave conditions under which that will not have been done. And it includes that you are trying to make sure of the appearance of the person before a court, or a person who have jumped bail, you have to detain him, or you're executing the sentence order of a court, or for a person under 18, you are trying to make sure he's educated and for his welfare. Somebody carrying infectious diseases, you are trying to make sure he does not spread it to the whole of society, or an illegal alien trying to enter Nigeria. And the part of the Constitution that deliberately says that you can, derogate from fundamental rights in the interest of national security, and all those other conditions, you find out that Section 35 is not included because all the conditions upon which you can derogate are already stated in the Constitution. So I dare say that that section of the Administration of Criminal Justice Act, if it is considered properly, could be declared unconstitutional. Not to even talk of having exceeded the number of days and you are still holding the person. It's like somebody has an agenda. Keep this person out of circulation. I don't like his face. Simply detain him one way or the other. 56 days is more than enough for you to bring a charge against somebody. And I'm saying that that section, if it is actually interrogated by jurisprudential minds who have an idea of the history of illegal detention in Nigeria and what the Constitution meant to prevent, that section will be declared unconstitutional.
You know, there have been concerns as to security agencies and their respect for the rule of law. And Mr. Femi Falana's point now points in the direction of a breach in the Constitution, and a concern as to whether this administration is going to continue in the stead of the former one to disregard court orders and all. But then there are also positions that the DSS or the federal government can reapply to extend the detention time. Is that true?
You cannot apply to extend a statutory provision, which gives you, first of all, you come with the first application. They give you 14 days to detain a person so as to enable you to conclude your investigations if you are really investigating. You come back again to say, oh, well, we've not finished. They give you a second 14 days to enable you bring this person before a court of competent jurisdiction. You come back a third time to say, oh, there are challenges, there are circumstances that have not made us to conclude. You ask for a third extension. They give you a third. First one was 14, second one was 28 days, third one you add another 14, about 42, and then the final one that gives it up to 56. How can you begin to apply? We are talking of a constitutional democracy. We are not discussing a military dictatorship. This is the kind of things that we are done under Decree 2. State security detention of persons, decree. Even when the courts gave orders, they say we house the jurisdiction of the court. How can we be discussing in a democracy, detaining a person who you have already accused of committing heinous crimes before the media for 56 days without being able to bring a charge? You recall the DSS was even trying to bring a charge against Emefiele under Buhari, and they were stopped by the courts. And then this time around, it has taken them so long. Okay, even when they eventually brought a charge, they discontinued it and bringing another one. So it's like you are going shopping. You're simply saying, I want to detain this man. If you bring excuse A, it doesn't work, you bring excuse B. So that does not show goodwill. That is not in accordance with the rule of law. It's about the rule of a man, men and women, filled with their personal prejudices and caprices. It's not about the rule of law.
So, Onyekpere, just before we go, you started off this conversation talking about your colleagues and their attitude to matters like this. I like to believe you're talking about the NBA. What do you expect the NBA to do?
No, my first position was about what I consider, I'm not a court, I don't sit as a judge, as the unconstitutionality of that provision. If you look at Section 35 of the Constitution, I had expected very senior colleague, distinguished senior advocates, the Nigerian Bar Association, to say this provision should not have been allowed in the law. It should not fly because it is open to abuse and that it has been seriously abused. And even if you allowed it and you see the mischief in the existing law, it should be a ground to call for an amendment of that law or a repeal of those provisions that allow the fundamental rights of the citizen to be abused. It's not about Emefiele or Bawa. I may not like their faces, I may not like how they performed in office, but that is beyond the issue because this could be applied to every other citizen who, for no reason or the other, the authorities don't like his face.
Well, what is the specific amendment you call for? Is it the number, the duration of the remand order?
I am saying the Constitution is the supreme law of the land. It says bring a person to trial under or bring him before a competent court under a space of 48 hours. And it's not for the purpose of remanding him if you don't have any evidence. It's for the purpose of offering him the opportunity to answer the case. So I want that section of the AJCA expunged because it's in violation of Section 35 of the Constitution. That's what I'm saying. I want people to be able to read that section, lawyers, jurists, journalists, and compare and contrast. Once you come to the point that one is contradicting the other, which means that one cannot stand, and the contradiction is coming from the Administration of Criminal Justice Act, it doesn't make sense to me because I was part of the people who were saying, don't allow holding charges to continue. And we got various judgments and decisions from the High Court and from the Superior Court to say holding charge is illegal, unconstitutional. And today we reintroduce holding charge through the back door and it is being abused.
Very well then. I'd like to thank you very much, Mr. Onyekpere, Lead Director, Center for Social Justice, for your time on Sunday Politics.
Thank you.